Okay, welcome back to another fun-filled episode of intellectual property. In today's class, we're going to be talking about the concept of patentable subject matter, or the fundamental kinds of things that can be protected by patents in the first place. So in previous classes, we've talked about the formal elements of patent law, namely claim construction. How do you determine what a claim actually covers or what it means? The definiteness and enablement requirement, as well as the written description requirement and the best mode requirement in our last class. So all of the elements that determine how a patent document is actually read and how you figure out what a patent document actually means. In our subsequent classes, we're going to be talking about the substantive requirements of patent law, or the sort of the things you have to show in order to actually get the patent, right? So in our previous classes, we've asked how to understand what a patent says. In our upcoming classes, we're going to be talking about how to figure out whether or not the patent should actually issue, and how to evaluate the validity of a patent. Okay, so we'll start with the patentable subject matter requirement, and that's provided for under Section 101 of the Patent Act, which says whoever invents or discovers any new and useful process, machine, manufacture, or composition of matter, or any new and useful improvement thereof, may obtain a patent, therefore subject to the conditions and requirements of this title. And you'll notice that under the language of the statute, it just says if you do any one of these pretty broad and broadly construed kinds of things, then you're potentially eligible for a patent. And it doesn't say when you're not, right? So it's really a patent about saying what kinds of things can be patentable, and then identifying things that are not patentable under Section 101 has really been done by the courts as kind of a judicial common law type gloss on what is included, right? So we ask first, sort of what's within the scope of 101. The answer is basically almost everything. And then we say, well, except for these particular kinds of things that have been determined not to fall within the scope of 101. And that's kind of inferred from the language of the statute without literally being within the statute itself, right? So what does Section 101 say can be patentable subject matter? Well, any process, machine, manufacture, or composition of matter. Those are all pretty broad categories, right? Those could include an awful lot of different kinds of things. And so the question then becomes, what kinds of inventions or discoveries would be excluded from the scope defined as patentable under Section 101? Well, courts have, broadly speaking, said that as a general rule, mathematical formulas, laws of nature, things found in nature, and abstract ideas, whatever that means, are not patentable subject matter. So in other words, they don't fall into any of these categories, therefore they can't be the subject of patent protection. There's a lot of dispute over whether a business method or a way of engaging in business activity falls within the scope of patentable subject matter as well. Currently, the sort of majority of the Supreme Court seems to think that it does, but there's a lot of disagreement, and a lot of justices and a lot of people in general think that business methods shouldn't be construed as being patentable subject matter. And I think what that underscores is the extent to which there's a certain amount of kind of prudential policy built into the concept of patentable subject matter under Section 101. In other words, why are these kinds of things excluded from the scope of patentable subject matter? Well, in part, arguably based on statutory construction, right? We say, well, it doesn't fall into any of these categories, right? But maybe in part it's also because we think that this is just too broad, right? I mean, giving people a patent in a mathematical formula as a formula would mean that other people wouldn't be allowed to use it. And it just doesn't seem efficient or productive. It seems like maybe that might be giving people too much. Same with laws of nature, or things that are already found in nature, right? what's the benefit? What's the sort of policy benefit of extending patent protection to those kinds of things? In other words, laws of nature, I mean, they're already out there. The fact that somebody kind of figured out what the law was, I mean, certainly it's very valuable and we want to encourage it, but maybe it's too much. Right? Maybe giving that kind of protection would be too extensive and therefore improper as a policy matter to grant. Likewise, abstract idea, I mean, maybe it's sort of like we think about, well, if an idea is sufficiently abstract that it's kind of like a formula or a law of nature, then maybe it's not the kind of thing we think ought to be patentable. And then the question kind of becomes, for business methods, becomes kind of framed as, do we really want to give somebody a patent-based monopoly over a particular way of doing business? Or do we think they ought to be trying to protect that sort of thing in some other format? In other words, are patents the right tool for doing that or not? Okay. Let's do a brief survey of different relatively recent, in most cases, anyway, at least from my perspective, cases in which the Supreme Court has reflected on the meaning of patentable subject matter, the scope of patentable subject matter under Section 101. And by way of introducing it, right, for a long time, 101 didn't do a whole lot of work, right? I mean, this sort of renewed focus on Section 101 and what it does and doesn't include within the scope of patentable subject matter is relatively recent within Supreme Court history. And one of the kind of the first cases in this kind of new wave of 101 cases was Diamond v. Chakrabarty. So basically, Chakrabarty had taken out a patent on a new microorganism that ate oil. Right? And the idea was we can manufacture this organism, it'll eat oil, and that will help in oil cleanup. And the question was, well, is a living thing, a living microorganism, the kind of thing that falls within the scope of patentable subject matter? And the court said, yeah, I mean, patentable subject matter goes to any process, machine, manufacturer, or composition of matter. A living thing is a composition of matter. And so essentially the Supreme Court said, look, as long as the living thing didn't already exist in nature, but was created by an inventor, created by a person, then it falls in the scope of things that can be protected, right? As long as it was made by a person, it's a composition of matter. It's the kind of thing that is within the scope of patent protection. Now, could there be kind of a specific statutory exclusion for certain kinds or certain contexts of living things? I mean, sure, absolutely. But that wasn't the question before the court, right? The question wasn't, is it good policy to extend patent protection to living organisms? The question was, do living organisms fall within the scope of the language of the statute? And the court said, yeah, it looks like it. Now, query, is that the right way to interpret what's going on under Section 101? Room for disagreement there. I mean, maybe the court should have been thinking more about policy when it made that choice, but it wasn't. Right? I mean, it just asked that question of, what does the statute say? And is this the kind of thing that falls within the scope of the statute? Okay, then in Diamond v. Diehr, the patent was over a mathematical formula, which wouldn't normally be patentable subject matter. But under the circumstances, that particular mathematical formula was applied in a particular context. And context of a particular new method of curing rubber. And essentially, the patent claim went to using this formula to control the rubber curing process. And so the response was, well, this patent's invalid because it's a claim over a mathematical formula. And the court said, well, yes, the mathematical formula itself isn't patentable subject matter, but the application of the mathematical formula in a particular context is. In other words, it's not the formula itself that's being protected, but the application of a formula in order to accomplish a particular goal. And the formula hadn't been used in that way before, right? And it wasn't the formula itself. It was a way of using the formula, right? So we've got two different elements here, right? On one side, we're saying, well, it's not a patent over the formula itself. It's a patent over the particular application. On the other side, we're saying, and the application is new, right? The question then becomes, what's really doing the work here, right? I mean, what's the role for 101 and what's the role for novelty? And are they really doing different things? So there's plenty of people who think that in reality, all the work being done by Section 101 might be done just as well by the other substantive requirements for patentability. In other words, maybe we don't really need 101, but maybe it does something arguably different, right? I mean, it is kind of framing the question differently, at least, right? Because in theory, under the novelty analysis, right, if the formula was new, then it's unclear why it wouldn't survive a novelty evaluation. And 101 does go a little further and say that the formula itself is not patentable. It's only a particular novel application of the formula that can be patentable. Okay, so in Bilski, we have arguably something kind of similar. So essentially, Bilski wanted to patent a method of hedging risk in energy markets. And the Supreme Court said no. And the Supreme Court said, look, this method of hedging risk is not something new. That's existed in the past, right? That's not novel. And therefore, you can't get patent protection over the method of hedging risk. And all you're doing is saying, apply it to energy markets. That's not enough, right? That's not the kind of thing that can qualify for patent protection. Now, query whether that isn't essentially the same thing that was happening in Diamond v. Diehr, right? I mean, formula already known, but patent over a particular application. That sure looks like what was going on in Bilski v. Kapos in a lot of ways, right? I mean, a method for hedging risk is essentially a formula, broadly speaking, and saying, well, apply it in this particular context. Well, that sure seems like the thing that ought to qualify. Now, maybe there's a problem with saying that it was, say, obvious, but we've got a non-obviousness requirement in the substantive requirements for patentability that could do that work. So is this an appropriate application of Section 101 or not? Should we be looking to the other substantive requirements, or is 101 the right way to exclude inventions or discoveries of this kind from the scope of patentable subject matter? Okay, in Mayo v. Prometheus, the patent that was owned by Prometheus was over a method of determining the correct dosage of a particular drug, and they sued Mayo for infringing that patent. Mayo's response was, look, this is not a valid patent in the first place. This isn't the kind of thing that can be patented under Section 101, right? And essentially what the method was to say, give the patient some drugs, see how they react to the drugs, and then change the dosage based on how they respond to the drug. I'm sure it was, arguably more complicated than that. But in a nutshell, that was the method that Prometheus was claiming a patent on. And Mayo said that's just not patentable subject matter at all. And the Supreme Court agreed, right? The Supreme Court said, essentially, this is saying guess and check, right? Like apply the drug and see what happens. That's just applying a law of nature, right? You're just saying, take the drug, give it to the patient, and then whatever the natural response to the pharmaceutical is, then extrapolate from that natural response. That isn't the kind of thing that is patentable either, right? You can't just take a law of nature, meaning the patient's response to the drug, and say, well, apply it, right? Look at what happens when you do this thing. That's just not enough. Now, query again, right? I mean, is this the kind of thing that's appropriate to exclude under Section 101 as non-patentable subject matter? Or again, can we just say, well, it's obvious, right? I mean, how else would you determine the dosage but to give the drug to the patient, see how they react, and alter the dosage based on the reaction? That's a pretty normal way of figuring out what the appropriate dosage of a drug ought to be. And it doesn't really seem like that's adding anything particularly interesting, novel, or non-obvious to a therapeutic regime. Okay, let's think then about Myriad then. So in Association for Molecular Pathology v. Myriad Genetics, the patent that Myriad owned was over two particular genes, BRCA1 and BRCA2, that were important to evaluating and treating various forms of cancer. And they accused the Association for Molecular Pathology. Rather, the question was whether the patents at issue were valid, specifically whether they were valid under Section 101. And the argument was, look, these are things that exist in nature and therefore shouldn't be the subject of patent protection. And the Supreme Court, after evaluating the evidence, tried to distinguish between the two genes in question, right? So one of the genes was actually extracted from an existing piece of DNA, right? So it was a particular sequence on the DNA strand, and it was identified and isolated by Myriad. Supreme Court said, well, if it's on the DNA strand and you just identified and extracted it, then it already existed in nature. It was already in the DNA. You didn't create it, right? You just identified its presence. That's not patentable subject matter, right? You've just identified something that already exists in nature. But the Supreme Court said that the other gene that was covered by the patent was what's called a cDNA, right? So that was actually manufactured in the lab by making a copy of an RNA strand in a kind of biologically sophisticated sort of way. And the Supreme Court said, well, look, the cDNA doesn't exist in the world until the researcher creates it. Therefore, that is patentable subject matter because, as in Diamond v. Chakrabarty, right, that DNA strand is made in the lab rather than existing in nature, right? So the Supreme Court tried to create this distinction between things that are found and things that are made. And it said things that are found, not patentable subject matter. Things that are made, patentable subject matter. That sounds really nice and clean, bright line test, easy to apply, et cetera, except for the fact that, unfortunately, a lot of scientists and Fozita said, what the hell are you talking about? Like, this doesn't make any sense at all. This second kind of gene is made in the lab only in a purely artificial, nominal sense, in that it's literally just a copy of something that does exist in the world, and it's done perfectly mechanically, right? So it's not really made in any meaningful sense. Moreover, right, this kind of cDNA is floating around in the world elsewhere. It just doesn't happen to be on the DNA strand or on every DNA strand. But it's not like it doesn't exist somewhere. I mean, it exists out there. It's just that it doesn't exist all the time. And this is a way in which it's kind of routinely manufactured. But this distinction kind of doesn't really make any sense. I mean, it sounds good on paper, but doesn't describe how the world actually works in practice. So a lot of people are pretty skeptical of the logic, the substantive logic of Myriad in thinking about patentable subject matter. Okay, and then in Alice v. CLS Bank, Alice has a patent over a method of settling intermediated risk on a computer. Well, what does that mean, right? What do they mean by settling intermediated risk? Well, essentially, Alice observed that when people are engaging in transactions, one risk associated with transactions is that you'll pay and the other party won't perform. Oh my goodness, right? Hugely new problem. Not really. It's been around forever, right? How do we fix it? Well, Alice says, let's adopt a method of hedging or settling intermediated risk in order to avoid that problem, right? How do we do that? Well, you give the money to a third party, and the third party doesn't give it to the transaction partner until the transaction partner performs. In other words, you have somebody in between who's the middleman who ensures that payment causes performance and doesn't allow the transaction to be complete until the entire until the entire bargain is performed. Now, is that a new thing? Of course not, right? The idea of settling intermediated risk is nothing new at all. That's been around since time immemorial, right? You look at the Babylonians, we're doing their meat world equivalent of the same on clay tablets and whatnot. But that's not new at all. What's new? Alice says, well, what's new is we've proposed a method of settling intermediated risk on a computer, right? We're proposing to do this thing, but use computers to do it automatically rather than have a person doing the risk settlement. And the Supreme Court said, no way, right? Just saying on a computer is not enough for there to be patentable subject matter. You've got to do more than just say on a computer. This is just taking an abstract idea that's already known. It's taking a formula or a method of doing something that's already out there in the world and just saying in a kind of really abstract way, bring a computer into the picture and have a computer do it instead of a person. Saying on a computer is just not enough for patent protection, right? And so not patentable subject matter. Now, why does any of this matter? Taking a big step back. Well, it turns out that for a long time, a lot of these kind of patents were actually issuing, right? So especially in a software patent context, but broadly speaking, there were a lot of what were generally seen as relatively weak patents that were making these kinds of claims. In other words, a lot of people were going to the patent office and getting patents over inventions and discoveries that were really basically in the Alice model of do it on a computer, or take this idea and, as in Bilski, do it in the energy market or whatever, right? Essentially saying like, look, do this in a particular way and do this well-known thing in a particular context, and voila, we've put two great tastes go great together. They sort of make a nice combination with each other. And the Supreme Court said, no, 101 is more stringent than that. We expect more for patentable subject matter, and therefore we're going to invalidate all these patents. And so, for a long time, there were a lot of patents for quite a few, years in the early 21st century. There were an awful lot of patents that were getting invalidated because they took this model, and even more that were just never defended because the patent owners realized that, well, after all these 101 cases, we're basically SOL if we try to pursue enforcement of this patent. However, a lot of people are concerned, right? Because a big problem behind 101 is that it's really hard to kind of discern any abstract generalizable principles that tell us with any predictability what kinds of things are patentable subject matter and what kinds of things aren't. In fact, there's a kind of ad hoc feel to a lot of these cases where it almost seems like the court is looking at particular circumstances and saying, well, does that look like patentable subject matter to us or not? And, what kind of post hoc rationales can we give to justify our decision? That one was found in the world and that was made in the lab, therefore we can distinguish in that way, right? Is that driven by the facts of the case, or is it driven by the Supreme Court's effort to explain why it reached a particular outcome under the circumstances? In a lot of ways, it looks like the courts are sort of grasping for a rationale to make sense of how patentable subject matter as a doctrine ought to work. And a lot of people think that's a problem, right? They want a rule that can be predictable so that patent owners and potential infringers can look at a patent document or patent application and say, okay, that's likely to be granted because it is patentable subject matter. Or that's not likely to be granted because it's not. Or that patent is probably valid, at least under 101, versus that patent is almost certainly not valid under 101, right? We want to know in advance so that we don't have to sort of roll the dice and see how the courts decide particular cases. They think it's a problem, creates transactions costs because it makes information sort of unclear, and they see this as being a real problem. On the other side, it seems like the outcomes in a lot of these cases aren't so terrible, right? I mean, these do seem like the kind of things that maybe shouldn't have been patents that issued in the first place, and invalidating them doesn't seem like such a terrible problem. I mean, these weren't huge contributions to human innovation. In fact, they seem pretty trivial and really not worthy of patent protection. They seem kind of opportunistic in a way. Like these people are getting patents in the hope of litigating them or collecting settlements on them rather than because they were actually innovating and planning to sort of add something to general human knowledge. Maybe if the court's reaching the right outcome consistently, it doesn't matter so much if there isn't a coherent, clear, predictable rationale? I mean, what do we care about more? Do we care about good outcomes, or do we care about the sort of formal benefits that come from predictability? I mean, it's kind of a toss-up. There's values on both sides, and there's at least the potential to be agnostic. And if we're getting good outcomes, does it matter if we can't always consistently explain how they were reached? I mean, maybe that's not really in the cards, right? Maybe it is kind of an ad hoc question, a policy question of, how do we identify the sort of tipping point against which particular inventions or discoveries ought to be patentable versus not? And maybe that's just different in different fields of endeavor and doesn't really admit of a generalizable kind of abstract rule.